The true danger is when liberty is nibbled away for expedience and by parts. Last year, it's my opinion, quite strong opinion, that through the National Defense Authorization Act, or NDAA, liberty was nibbled away at. And it's a troublesome notion that we seem okay with handing over some of the powers of Congress to the executive branch, which has now had this trend since 9/11 to kind of like cast that checks and balances aside and invest it in one office, one individual. Each year, Congress authorizes the budget of our country's Department of Defense through a National Defense Authorization Act, or, as I indicated, NDAA. Last year's bill contained a subtitle addressing issues related to detainees at the United States Naval Station at Guantanamo Bay in Cuba. And more broadly, it offered the disposition of persons captured in the course of hostilities against Al-Qaeda and associated forces to be dealt with differently. Much of the debate centered on an effort to confirm or expand the detention authority that Congress implicitly granted to the President via the authorization of use of military force in the aftermath of 9/11. I thought these were deeply troubling provisions governing the handling of terrorism suspects by United States authorities. Specifically, provisions were added to the bill in the Senate that would put into law the authority for methods such as indefinite detention without charge and mandatory military detention. These provisions would authorize the use of these methods on the basis of suspicion alone, to virtually anyone picked up in anti-terrorism efforts, including those arrested on United States soil, and could be including United States citizens. In effect, this would give our president, the president, any sitting president, I don't want to personalize this to President Obama, it would give our president, our nation's leader, the authority to send the military literally anywhere in the world to imprison civilians without charge or without trial. Imprisonment could be based merely on that suspicion. No corner of the world, not even our own homes, would be off limits, and the government would have the ability, the awesome ability, to lock up American citizens without charges or trial. The inclusion of these provisions, which blatantly violate our constitutional rights as Americans, generated severe condemnation not only from civil liberties groups, but from the very highest ranks of United States national security leaders. So I think it was reason for cause here of concern. The detainee provisions were opposed by many, including the Secretary of Defense, Leon Panetta, the Director of National Intelligence, James Clapper, our CIA Director, David Petraeus, our FBI Director, Robert Mueller, White House Counterterrorism Advisor, John Brennan, the Assistant Attorney General for National Security, Lisa Monaco, and then finally the General Counsel for the Department of Defense, Jay Johnson. Facing the threat of President Obama's veto, these provisions in the NDAA were significantly altered. There were those who tried their best to make this act work, and it just didn't, I believe, address it appropriately and nearly well enough, especially since the core mission here was to, I think, give blatant power and remove the checks and balances from the House of Representatives and the United States Senate. However, I have to agree with FBI Director Mueller that these changes did not resolve our national security concerns, nor did they fundamentally change the provision that further enables indefinite military detention of terrorism suspects and threats to the inalienable due process rights that have always been afforded to every American citizen under the Constitution. Those are parameters that I think are very severe and should be very much respected. The bill still gives the President the authority to indefinitely imprison American citizens without charge or trial, and as such, I felt I had no choice but to strongly oppose the NDAA, and therefore chose to vote against it. There were a couple of amendments offered on the House floor so as to fix the bill. The first was from my colleague Adam Smith, who is our ranking member of the House Armed Services Committee from Washington State. His amendment would have allowed for the transfer of detainees to the United States for the purpose of standing trial in a federal court. It makes sense. I thought it was a strengthener, of course, and I voted for the amendment, but it failed by a count of 165 to 253. The second was an amendment by Justin Amash, a Republican from Michigan. It would have eliminated the provision included in the bill, expanding the authorization of the use of military force. I voted for this amendment again, but it also failed by a vote of 187 to 234. Unfortunately, and again, with these slighter modifications, this final version of NDAA, still unacceptable, unfortunately became law. But our fight, I believe, to cover the protections that we require from these reprehensible civil liberty violations must continue. As such, I have not sat idly by since the NDAA's enactment, but have continued to work with my colleagues to pursue opportunities to right this wrong. First, I joined with my colleague, Congressman John Garamendi, a real strong advocate on several issues with which I agree. And as a Democrat from California, he and I have worked on several common bills. He has introduced the Due Process Guarantee Act of 2011. This bill amends the Non-Detention Act of 1971, clarifying that a congressional authorization for the use of military force, such as that in the NDAA, which included the various detainee provisions, does not authorize indefinite detention without charge or trial of United States citizens apprehended on United States soil. Second, I recently joined with Ranking Member Smith as a co-sponsor of his bill, the Due Process of Military Detention Amendment Act of 2012. It would ensure that any individual detained on United States soil has absolute access to due process and to the federal court system. Specifically, the bill would amend Section 1021 to clarify that any person detained in the United States pursuant to the authorization for use of military force would only be subject to trial and proceedings by a court established under Article 3 of the Constitution or by an appropriate state court. This legislation would also repeal Section 1022 of NDAA, which requires mandatory military custody for those detained overseas. Our civilian law enforcement investigations have a proven track record of success and have provided intelligence and admissible statements without Miranda in crisis detention situations, as demonstrated by the recent mandatory life sentence received by the underwear bomber. Over 300 individuals convicted of crimes related to international terrorism are currently incarcerated in federal prisons within the United States with no escapes or retaliatory actions. Our civilian courses over a broad set of offenses, giving our federal prosecutors a wide range of tools, can be used to incapacitate suspected terrorists. Our civilian courts enhance international cooperation. A number of countries have indicated that they will not cooperate with the United States in certain counterterrorism efforts, for example, in providing evidence or extraditing suspects if we intend to use that cooperation in pursuit of a military commissioned prosecution. I think that we have to be very careful in labeling ourselves as something other than the unique American fabric that has guided us through the years. All of the use of military commissions in the United States can be traced back to the early days of our nation, and is an effective tool in presenting evidence obtained from the battlefield. In their present form, they are less familiar to the international community than one civilian criminal justice system and Article III courts. The United States was founded on the promise that justice is an inalienable human right, and that all American citizens, regardless of their suspected transgressions, are entitled to the due process of law. This is exactly what I believe is at risk, that due process of law. The America I believe in and know and love, the America all of us in this room know and love, does not throw people in prison indefinitely without an opportunity to face the charges against them. Given your passionate advocacy that I know is contained in this room, I hope we can all stand together to continue to work together to fight to reclaim our constitutional rights. Let me close with a quote from George Bernard Shaw, who in 1930 wrote, "Liberty means responsibility. That is why most people dread it." Let us take this responsibility seriously and fight to keep America the land of the free. This is absolutely what ought to guide us. And you know, it seems so unusual to me that since 9/11, there's been this propensity to want to just feed the power to one individual without providing for the checks and balances. And in so doing, really putting consequences out there as the prime outcome that will come down hard on individuals who could be so unrightfully charged, wrongfully charged, in a way that we will regret these actions. So I would encourage all of us in this room to continue to fight for the protections that are guaranteed in our Constitution and work in a way that keeps the balance of the justice that should exist between the legislative branch and the executive branch, so as to continue that uniqueness of America that I think is held high by so many around the world. Why would we want to weaken that? Why would we want to strengthen it? So thank you for your kind attention. And I'm told that Dr. Sybil is going to allow for comments and questions that you might have.